Hello, Dr. Michael Arnold here again, and Bernard the Barrister Bear. And this video is called Footballers' Wives, because it's about the supposedly high-profile case, defamation case, between two prominent footballers' wives. I never heard of the wives, and I'd only heard of one of the footballers, Jamie Vardy. I've not heard of him, but it's between his wife and the wife of Wayne Rooney. I had heard of Wayne Rooney. But I've got to say, the case itself I found very boring, even though it has been turned into a 2-hour or 2-part television special, supposedly how important it is. I don't agree with that verdict at all. But I have to admit, I only watched probably about 5 minutes of it before switching off out of utter boredom. Gossip! Gossip! Well, of course, Bernard is right that it's all about gossip. It's a defamation case about gossip, and people are interested in gossip, although I found that the gossip involved in this case, I think, very boring. And more importantly, why should a case involving this sort of thing end up in court anyway? But more to the point is the costs. We're told that the losing party had to pay £1.5 million in costs. That means legal costs to the other party, to the winning party, which is absolutely eye-watering. Though perhaps not to these particular people, because of course we know footballers, and especially the top footballers, earn big money. But the problem with costs is not confined to defamation cases, although defamation cases are notoriously expensive. But the problem with costs in this country is more general, and I will be doing a separate video on that. But for now, I want to concentrate more on defamation, because that's what this case was. It was a defamation case. One wife claiming that the other had defamed her online, and so on. It's quite complex, but that's the bare bones of it, is defamation. Defamation, and as we know from Lord Neuberger, the former president of the UK Supreme Court, the whole area of tort is in a state of disarray. 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 And lacking reliable principle. And defamation is part of tort. Though Lord Neuberger didn't focus on that specifically, he was talking about tort cases in general. There is in general this problem. They're in a state of disarray, which is very worrying. I have dealt with it to some extent before, and I will come back to it again in future videos, because it is really serious. Most areas of tort are in disarray because there are no very clear principles, because the area of tort has not been legislated on very much. There are certain isolated spots within tort where there is legislation, but mostly not. And as a result, there's a vacuum which the judges have necessarily been forced to fill. That's why I don't blame the judges, and I have called previous video, "Don't blame the judges," because the fault really lies with Parliament for not legislating in this area. And that really means the government, because Parliament is really controlled, in practice, controlled by the government. But defamation is an exception. There is a lot of legislation on defamation, perhaps too much. It all goes back to 1888. There was an Act of Parliament then about defamation. 1952, a major piece of legislation. 1996, another very major one. And now, most recently, 2013. But the problem is that they are all still in force, all those laws. And they all are superimposed on the common law of defamation, which also is still valid. Well, if that doesn't create disarray, then what does? When the 2013 legislation was passed, Nick Clegg, who was then Deputy Prime Minister in the coalition government, said it was necessary because the English law of defamation at that time was a laughingstock around the world. He himself said it. The English law of defamation was a laughingstock. Well, he's right. But unfortunately, the 2013 law has not really improved matters that much. It should have, but unfortunately it hasn't. And one of the main reasons it hasn't is because Nick Clegg, or people in the government at the time, did not think of consolidating, we use the word consolidating, the law of defamation into one Act of Parliament. Is that too much to expect? The area of defamation law is not that wide, and it could easily be contained in one fairly compact Act of Parliament. Why wasn't that done? It's because the whole concept of streamlining the law has been neglected in this country for centuries, compared, for example, to America, where, although it's also supposedly a common law system, everything is not only consolidated, but codified. That means whole areas, the whole of the law, or at least large areas of the law, are put into one single cohesive whole. Why has that never been done here? Yes, they talk about it all the time. They've been talking about it for 300 years now, but nothing has happened. Nothing has happened. Well, very little, I should say. Very little. As a result, in America, English defamation decisions are not recognized. They are simply not recognized. There is the so-called Speech Act of 2010, which is SPEECH, and as quite often in America, that is an abbreviation for a longer title. They often like to find a catchy abbreviation for a law, and it really stands for Securing the Protection of Our Enduring Established Constitutional Heritage. Well, obviously, that was specially devised, that long title, in order to make a word which was memorable, and this word is speech, which is memorable because it relates specifically to that. It's about defamation law, or libel, tourism, as it is sometimes called. Libel, of course, defamation is in two parts. Libel, which means anything defamatory which is in permanent form, written down, or in fact radio is counted as being in permanent form as well, although it isn't always. Libel, and slander, which is just unwritten defamatory remarks. Someone making a remark orally without it being recorded. That's slander, but most defamation actions are in fact for libel. But together, slander and libel together form defamation. But the Speech Act of 2010, you might say, well, that predates the 2013 UK Act. It does, but it's still in place because Americans did not find the 2013 Act actually solve the problem. And what is the problem exactly? The problem is that English Defamation Act, English defamation law, does not recognize the importance of freedom of speech sufficiently. Freedom of speech, which is actually enshrined in the European Convention on Human Rights. So we've got a conflict of laws within our own law. In America, they have the First Amendment, which places freedom of speech on a very high pedestal. And that is why they feel English law of defamation doesn't respect freedom of speech enough. Some fairly trivial breaches of free speech can suddenly result in a defamation case in court. And what's even worse, you have so-called super injunctions, where very rich people, usually again very often footballers, can go to court and actually get articles in newspapers suppressed before they are printed. Well, of course, we know that the British press is extremely anxious to sell very, very, I would say, colorful stories. And as a result, they're not as careful as they should be, perhaps, in what they say. But even so, to have this provision of a super injunction where you suppress freedom of speech is something that you could certainly never have in the United States. More next time.